Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to podcast number 138. I feel we're getting back into the swing of these now and summer is receding into the distant past. Mind you, I don't know about you, but my day started with realising that my wife had walked off with my glasses and glasses case. So we'll see how we do on this podcast. With three cases, of course. First one is the one that probably caused the most comments. It relates to an attempt by a claimant to rely on material which would normally have been legally professionally privileged, but which was leaked to the other side. Could the claimant, considering the document was leaked, use it in the particular circumstances of this case, despite the fact it was privileged? Secondly, we have a case on the circumstances in which employees who are continuing to work under protest about adverse changes imposed on them by the employer are taken to have consented to the change by virtue of the passage of time. Thirdly, and in a situation I wouldn't wish on anyone, we have a case dealing with a wasted costs order, which is an order in a tribunal setting against one party's legal advisers to pay or contribute to the costs of the hearing. This case, in effect, sets out some fairly important limitations on the usefulness of the wasted costs orders. As always, please don't forget you can access our podcasts through the website, LinkedIn, iTunes, YouTube, and we put out the links to all the cases on Twitter. So on with the show. X and Y Limited. Well, the claimant worked for the respondent as a lawyer for 17 years. We don't know the name of the claimant or the respondent because they've been anonymised for reasons that are not entirely clear in the judgment, and clearly there's quite a lot going on in this case. The claimant, we're told, is disabled. He filed a disability discrimination claim in August 2015. This was the first claim. He then filed a grievance, also containing references to disability discrimination, in March 2016. In April 2016, the respondent placed the claimant in a redundancy consultation process and he was ultimately made redundant. However, according to the claimant, and this was accepted by the Employment Tribunal, in May 2016 he was in a pub on Fleet Street. The claimant gave evidence to the tribunal that a group of professionally dressed people came in, including two women. One of the women mentioned dealing with a complaint by a senior lawyer at the respondent, and that the claimant had brought a disability discrimination claim. The woman then went on to say that there was an opportunity to manage the claimant out because of the reorganisation that was underway. Obviously, I'm summarising a longer piece of evidence in the tribunal judgment. Then, in October 2016, the claimant was sent an email anonymously via the post. It was headed legally privileged and confidential, and it was an email sent between two lawyers working for the respondent. Since it is claimed that the email is legally professionally privileged, we do not have the details of the full email in the court judgment, but the claimant asserted that the email contained advice on how to commit unlawful victimisation by cloaking his dismissal within the redundancy restructuring programme. The respondent did dismiss the claimant in January 2017 and the claimant started a second claim in March 2017. Well, the first question the court had to decide was, what did the disputed email actually mean? Although the Employment Tribunal had thought that the email was advising on the risks of following a particular course of action, the EAT disagreed. The EAT accepted that the email was advising that the redundancy exercise could be used as a cloak for dismissing the claimant, who was troublesome to the respondent. In reaching this view of the email, the EAT did not take into account the conversation that had been overheard. The conversation in question had not been authorised by the respondent, obviously. It was simply two colleagues speaking. Therefore, it could not be taken to be of help in deciding what the respondent's position was in relation to the claimant. The EAT also noted that no contemporaneous note had been made of the conversation by the claimant. The EAT agreed that it would have been unsafe for the Employment Tribunal to rely on evidence of that conversation to interpret the document, to interpret an email that had been written several weeks earlier. However, as I say, the EAT accepted that just looking at the email itself, they were clear that the email contained advice on how to cloak the respondent's dismissal of the claimant in a redundancy exercise. Secondly, having decided this, the Employment Tribunal and the EAT had then had to consider whether the claimant could be permitted to rely on the document that had leaked to him. He did so on the basis that although it was potentially legally professionally privileged, passing between two lawyers, the advice in the email amounted to, quote, advice sought or given for the purpose of effecting iniquity, unquote. Now, bit of background. Legal professional privilege is based on public policy. Generally, documents covered by legal professional privilege cannot be disclosed unless the owner, usually the client, waives that privilege, and then there are rules about that. The underlying rationale, of course, is people need to be able to disclose concerns to their lawyer without fear they're creating evidence to be used against them. However, we've also known for many years that if a lawyer is giving advice for the purpose of effecting iniquity, that is not privileged. This is generally known as the iniquity principle. The burden of proof is on the person seeking to establish that iniquity exists, and it is up to the person trying to rely on the disputed material to show that there is a strong prima facie case of iniquity. Remember that the EAT has decided that advice laid out in the email includes advice on how to treat the dismissal of the claimant as if it were a redundancy, i.e. it was not a redundancy, but it was going to be presented as a redundancy. The tribunal judge decided that a strong prima facie case had been established, that what was going on here was an attempted deception of the claimant as to the reasons for dismissal, in circumstances where these were potentially discriminatory. But also, if the case had gone all the way, there would be deception of the Employment Tribunal, because presumably witnesses would have been given evidence to that effect as well. The EAT was careful, and rightly, to say that whether or not the advice given was in fact done to perpetrate or further iniquity was not for them to decide at this stage. That point has not been decided. It was enough for them to identify that there was a strong prima facie case, so that the claimant could rely on the email in front of the tribunal which was hearing the full case. On that basis, the EAT decided that the claimant was entitled to rely on the email which had been sent to him anonymously. He was also, of course, entitled to rely on the conversation which he had apparently overheard in the pub. I think there are several points coming out of this case. Obviously, if you are a claimant and you overhear a conversation like the claimant did here, you need to make a contemporaneous note. That may not affect the outcome overall, but that's a start of a 10. It's also an object lesson that matters may easily become known to the other side, even though this was a long way from being contemplated at the time the advice was being given. The two women in this case, allegedly talking about this matter, would not have expected their claimant, their conversation to have ended up in an employment tribunal. The sender of the email, I'm sure, did not draft it with a view to it being scrutinised by a trial judge. However, with employees able to covertly record conversations, disgruntled employees able to access emails within company systems and send them on, or damage their employer, or maybe an employee who was formerly part of a management team being let go and determined to wreak havoc on his former employer, these sort of situations do arise. Indeed, I had a similar thing. I remember my very, very first case back in 1988 concerned a woman sitting on a bus who overheard two guys in front of her planning to rob the bookies that belonged to my client that afternoon, and that made its way to the police and then made its all the way to an employment tribunal situation when we didn't tell the staff concerned about the potential raid. So, here, obviously, the first point, if you're an advisor, is to ensure that your emails and notes of advice are always written in terms which will withstand the scrutiny of a tribunal judge. Clearly, it's never appropriate for advisors to be advising how to lie to a tribunal or court, or to give advice about how others may do so. That's, of course, a common understanding between advisors and their clients. But it's important that emails or advice between parties who share that common understanding appear in the right light to a third party, i.e. a tribunal, who may not necessarily start with that common understanding or assumption. Additionally, although it's often surprising to employers, here, and usually, it is completely irrelevant that the particular email had been obtained unlawfully and should never have been sent to the claimant. The EAT's comments about cloaking the dismissal will strike a chord with many. I'm sure claimants will often believe that their dismissal for an alleged redundancy is in fact a smokescreen for something else. Equally, employers hearing about this case may feel the case is going to be used as a crowbar to attack legal professional privilege. I think it's important not to forget that there has to be a strong prima facie claim of iniquity before the material is disclosable. Tribunals need no reminding of the importance of the role of privilege, and fishing expeditions for privileged material without any evidence are undoubtedly going to fail. Therefore, if a claimant is going to get hold of such material, it's likely either it's going to be leaked or hacked, or possibly an individual disclosing material to the employee on their departure. Whilst a lawyer who's advised orally may be vulnerable to have advice misquoted back at him or her, or misrepresented if made available to the other side. If a lawyer has ensured that any advice is in writing and is clearly on the right side of the line, in this case advice on the risks of redundancy as opposed to how to cloak the redundancy, the lawyer will be in the clear and the advice will remain privileged even if it is leaked in an unauthorised manner to the claimant. So that's the case of X and Y Limited, and the claimant was able to use material that would otherwise have been privileged and non-disclosable because someone leaked it to him and it indicated a strong prima facie case of iniquity. So next up, KL Law Limited and Wincanton and others. This is a sort of situation you wouldn't wish on anyone. The claimant brought proceedings against the respondent for discrimination and constructive unfair dismissal. The matter goes all the way to a substantive full hearing, and on the third day of a 4-day hearing, it became apparent that certain diary entries existed in a diary kept by the claimant. Those diary entries had not been disclosed to the respondent during the disclosure part of the litigation. Equally, some of those diary entries apparently did not support what the claimant was claiming had happened. As a result, the claimant withdrew her claim during the tribunal hearing. The tribunal then heard an application by the respondent's lawyers for a wasted costs order. On the grounds that the claim by the claimant was misconceived, disclosure must have been handled negligently by the lawyer. At the employment tribunal stage, the tribunal found the issue was whether the representative acted improperly, unreasonably, negligently, etc. And secondly, if they did so, had that caused the party applying for costs to incur unnecessary costs. Finally, the tribunal said it had to consider, in the circumstances, was it just to order the representative to compensate the other party for the whole or part of those unnecessary costs. Here, the tribunal found that an order should be made against the claimant's representative and ordered the adviser to pay £6,300 as a contribution to the respondent's total costs. Well, the paying party appealed to the AT, and there were a number of grounds that they sought to raise. First of all, they pointed out there was no evidential basis for the tribunal to conclude that the lawyer's conduct amounted to negligent conduct. Privilege had never been waived by the claimant employee themselves, and so the lawyer was unable to respond to the tribunal or the AT as to what his instructions were and what his advice was on the issue of disclosure. Moreover, it was pointed out, even if the lawyer had been negligent, there was no evidential basis to determine whether or not the claimant would have listened to the competent advice and decided not to pursue a claim. Therefore, the legal costs incurred by the respondents could still have occurred, even if the lawyer had been negligent. Well, the AT clearly had a fair amount of sympathy for the claimant's representative in this situation. The AT pointed out that if the wasted costs application is disputed, it's likely to be highly material what instructions the client gave to his or her representative. Legal professional privilege in those circumstances applies and can only be waived by the client. As a result, it may be very difficult for the respondent, the representative rather, to provide a full answer. To the extent there is doubt in such cases, then the EAT said the tribunal should give the legal representative the benefit of that doubt. Applying that here, of course, we've no idea what advice was given about the disclosure exercise. Therefore, the EAT accepted there was no basis for an inference that the claimant's failure to disclose was an abuse of process by the claimant's lawyer. Equally, the tribunal could not know what advice the claimant had been given. If the claimant's lawyer had given advice to say that the claimant's case was poor or hopeless, and the claimant had elected to carry on regardless, there was no loss flowing from the claimant's lawyer's advice. The EAT was also very clear that a wasted costs order should only ever be made after careful consideration by the tribunal, and should be dealt with very carefully, because a wasted costs order is a serious sanction. Findings of negligent conduct by an adviser are serious findings. Quote, the tribunals should proceed with care in this area, unquote. I think that, with the greatest respect, this decision is a very sensible one. It's very difficult for a representative to defend himself or herself if the representative is unable to rely on the advice that they gave. If the lawyer and his or her client have fallen out spectacularly, the client might waive privilege and so open up the course of correspondence. But that's exceptional. In general terms, I think the benefits applying for a wasted costs order are pretty dubious. If the client concerned would not have followed the advice, or might have caused the legal costs in any event, this seems to undermine the value of any damages claim. So my take generally is that it's very difficult to see the benefit of applying for a wasted costs order. not least because any law firm or representative against whom it is made is going to fight it tooth and nail and appeal at every turn. In the circumstances, it might often be easier to make an application against a claimant or respondent directly than to get caught up in wasted costs orders, even if the prospects of actually being able to enforce that costs order against a, say, impecunious claimant may be limited. So that's KL Law Limited and Wincanton and others, and wasted costs orders against legal advisors are usually not the answers. Third and final case, Aberhall and others and Nottingham City Council. This is a pretty complicated case factually, and I'm going to deal with it briefly since it's the third of our three cases, but I did want to bring it up. In essence, Nottingham City Council was facing a collective claim under what I am afraid to say I still think of the Wages Act, now the Employment Rights Act 1996, i.e. 22 years ago. It was a collective claim for unlawful deduction from wages. The claim in essence was that the individuals were entitled to guaranteed annual pay rises which had not been forthcoming from the council. As I say, the case is factually quite dense, and I don't think there's any need to go into the detail of it in this podcast. There were, in essence, three different categories of claimant, all employed on slightly different terms. In one category, the EAT found that there was a contractual right to have a pay rise, and this was effectively written into the contractual documentation. In relation to the other two groups, the EAT said the position was much more generalised and there was no such contractual entitlement. However, since the context for the dispute arising was against the background of the employer wanting to move all individuals onto the same contract, the Court of Appeal was willing to read into those other two groups of contracts the right to have a guaranteed annual pay rise as well. They did so by reference to the factual context and the extent to which one group already had the contractual pay rise was a relevant aspect. I am, as I'm sure will be apparent, significantly simplifying a more complicated situation. However, the point is that the Court of Appeal was willing to look at the wider picture and the existence of a clear-cut contractual entitlement for one group of staff and the fact that the employer had been looking to move all staff onto the same terms generally during the recontracting exercise. The decision by the Council, therefore, to freeze pay was a breach of contract. However, the employer had frozen pay from 1 April 2011. The unions had protested, but there had been an insufficient mandate for strike action. The Council's position was if these changes were not accepted, then there would need to be redundancies. They'd said this on a number of occasions. The freezing provisions, which were in place from 2011 to 2013, were then extended, and a formal grievance was activated by the trade union representing some of the claimants in 2013, i.e. 2 years after the freezing had initially taken place. At no point had the individuals or the union ever expressly accepted the change. So, having identified that there was a contractual right to have annual uplifts, the Court of Appeal had to decide whether the individuals had effectively varied their contracts by agreement or waived any claim because of the passage of time. And this is, I think, the more interesting part. Court of Appeal reviewed the law in this area and said that one should only identify a waiver by an employee of a claim if their conduct, viewed objectively, clearly evinces an intention to waive the claim or accept the variation. Obviously, if the variation is that the employee has been giving some benefits and some detriment under the revised terms, and the employee takes the benefit, that will be conduct evincing an intention to accept the whole contract. However, where the contract changes are solely disadvantageous, i.e. there's no benefit within the contract for the employee was entitled to the benefit of any doubt as to whether or not their failure to take action amounted to a waiver or consent. The Court of Appeal did make comments that indicated they could accept the concept that employees could agree a disadvantageous variation to their contract in return for avoiding redundancies. That was a concept they could understand. But the problem here was the Council had not bound itself to stay away from making redundancies if the employees accepted the terms. They'd simply said that if the terms were not accepted, then redundancies would be the alternative. Well, I don't know if this case is going to go any further, but if it is not, then I imagine the employer is feeling pretty bruised here. Several years down the line, it has been found to owe employees sums going back to 2011, which were contractually due to them. You could anticipate that the employer would have felt after 2 years that if there'd been no legal action, then employees had in practice accepted the change. Equally, the lack of active opposition between 2011 and 2013 would have meant the employer was probably pretty confident the employees had waived their right to object. I think the existence of a collective right to object to the imposed change is important. Given that the unions had voiced opposition, this was in effect applied to their members and those they represented, even if the individual himself or herself did not voice any protest. I think the employer may in retrospect have been better to offer a commitment that unless circumstances change materially, it would hold off making any redundancies if employees accepted the changes and did not seek to challenge them. Well, in short, this is a cautionary tale about introducing wholesale contractual changes and pushing the contractual change through without going through the normal contractual variation process. Although, as I hope I made clear, I have some sympathy with the employer here, given that in at least 2 out of the 3 categories, the Court of Appeal had to do some work to imply a right to vary the contract, and both the the right to a contractual pay rise, and both the Employment Tribunal and the EAT agreed with the employer in respect to those particular categories. So that's Aberhall and others, Nottingham City Council, where the employer has to reimburse employees who've been denied pay to which they were contractually due under an annual pay scheme. The fact the employees had waited more than 2 years before bringing claims did not, on the facts of this case, prevent those claims being brought. So that's it for this podcast. Thank you very much for listening. As always, I hope you enjoyed it. Hope you find it useful. I will be back in 2 weeks' time, podcast 139, as we march on towards podcast 150, probably sometime early next year. I hope you have a good weekend, and speak to you again in a couple of weeks. Bye.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances, so please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.